Sorry.
Okay, call our next case, 128203, State of Kansas versus Blinda Alpert.
Morning, Your Honors. May it please the court. The State of Kansas appears by Jacob Gonteski.
Would you like rebuttal time, Mr. Gonteski?
I would, Your Honor. I'd request 5 minutes. Thank you.
I guess I'll announce my appearance. I'm not used to being appellee. Please, the court. Appellee Blinda Alpert appears with counsel Kate Zigtema for the purposes of oral argument.
Well, think about it, Ms. Zigtema. No rebuttal, so that's nice.
One and done.
Mr. Gonteski, whenever you're ready.
Thank you. Jacob Gonteski for the appellant, the State of Kansas. I am here today requesting that you reverse the trial court's order suppressing evidence in this case. This is an interlocutory appeal from a district court ruling which suppressed essentially all the evidence that the state had gathered in this DUI investigation. And I'm asking that you reverse the district court's suppression of evidence because it erred at every step along the way in finding that either reasonable suspicion failed to support the officer's DUI investigation here, or that probable cause failed to support the officer's arrest of Ms. Alpert in this case. At both turns, the district court erred. I'd also like to address, at least for a couple of minutes, why this court should revisit an issue that was addressed by one member of this panel last year, which is a threshold matter for the state raising an interlocutory appeal. And this court should again recognize that the state need not demonstrate that the suppression order that it is appealing, quote, substantially impaired the state's case.
That's contrary to the law.
It's contrary to Kansas
Existing law.
Correct.
Kansas.
It is contrary to Supreme Court precedent in Kansas, correct.
So are you only asking for reversal so far as it addresses the DUI charge?
I believe the DUI charge may be the only charge that remains because the case was originally filed as a felony, not for the DUI being a felony, but the marijuana possession was a felony charge. And there was a preliminary hearing that was held at which point the district court did not bind over on the felony charge, but did certify the misdemeanor to go forward. So
The misdemeanor being the DUI.
correct.
All right.
And so what we are here on is essentially solely being able to continue prosecuting the DUI charge. We're not seeking to reinvigorate the felony marijuana charge. We did not appeal the district court's denial of probable cause at the preliminary hearing. We are only seeking to reverse the district court's suppression of evidence. And the reason why this court should reverse the district court's suppression of evidence is that all of the evidence that was presented both at the preliminary hearing and at the suppression hearing showed that this officer acted reasonably at every step along the way. The Kansas Supreme Court and panels of this court have recognized that the best approach for an officer to utilize in a traffic stop is a graduated approach, one that responds to the circumstances that they are confronted with. This officer first approached Ms. Alpert driving on a county road in the middle of the day and recognized that she was failing to maintain her lane of travel. She drifted over the center line more than once and then approached a stop sign intersection and straddled the lanes at that intersection, appeared indecisive on which way she was going to go, eventually moved on through the intersection, and the officer conducted the traffic stop for the failure to maintain a lane. That right off the bat was an indicator for the officer that conducted the stop that the driver may be impaired. When the officer then stepped up to the side of Ms. Alpert's truck, it's a work truck. She was working at the time for a landscaping company. And when the officer approached the side of the truck and explained to Miss Alpert why she had stopped her. Within the first minute, the officer vocalized that she smelled an odor of marijuana emanating from the truck and asked why that would be the case. So we have another indication, another observation by the officer at that point that something more than just drifting over the lane may be afoot.
And as I understand it, there's no challenge to the probable cause for stop.
Correct. Ms. Alpert conceded at the outset that the officer had reasonable suspicion to conduct a stop on the vehicle. So the stop is not questioned. So the officer had justification to be at the side of the truck at the driver's window and conversing with Ms. Alpert. And while the officer was there, that's when the officer smelled the odor of marijuana emanating from the truck. This court and the Kansas Supreme Court have recognized that the odor of marijuana, whether it be raw or smoked, emanating from a vehicle, provides probable cause to search the vehicle for marijuana. The officer did ultimately search this truck and found lighters in the truck, no cigarette paraphernalia anywhere, and also found an Altoids tin that the officer stated reeked of marijuana, and then observed some leaves, some shake of marijuana on the seat of the truck.
And this is where it's kind of troublesome to me with the district court's ruling, didn't its disagreement with the way the officer proceeded at that point with that search, did that bleed over into his finding with respect to the DUI? And if so, isn't that problematic with respect to his ruling that can't play a part in the suppression of the DUI?
It is tough to square the two, and it's tough to get a full appreciation for what Judge McCarthy's observations at the preliminary hearing meant for his suppression hearing. It meant for his suppression ruling, because he did not issue a written ruling, but he did, other than to recognize what he stated on the record at the suppression hearing. And so he did recognize that let me step that back. I believe at least one of the parties at the suppression hearing asked the court to take judicial notice of the testimony it had already heard at the preliminary hearing. So the court was in a position to utilize the testimony it already heard from the preliminary hearing, as well as the additional testimony it took at the suppression hearing. And what it was about the testimony from the preliminary hearing that gave Judge McCarthy pause at the suppression hearing appears to have been his recognition or giving substantial weight to the fact that there was some testimony that the truck that was being driven by Ms. Alpert was a work truck. It was not owned personally by her, and that it may have been driven by others. There was
nothing to do with the DUI.
Correct. And so to the extent that impacted the trial court's ruling on probable cause for the marijuana possession, it should not have in any way impacted the suppression ruling, because the suppression ruling was about suppressing not just the physical evidence that was found in the truck, but everything that flowed from the DUI investigation, meaning her submission to a blood test, and a blood test that was conducted, results that were provided that are part of the discovery in this case, that was all suppressed as a result of the district court granting the defendant's motion to suppress. And so every step along the way, this officer, though, had the requisite either reasonable suspicion to evolve the stop from a traffic infraction investigation to a DUI investigation. Further, the officer had the probable cause to search the truck for marijuana, which was found. And when confronted with that, Ms. Alpert admitted to officers that she had smoked marijuana approximately 4 hours earlier that same day, and then later discussed how she had smoked the night before as well, and that would be in her system. And then with all of that, along with the observations of impairment that were apparent to the officer during the field sobriety testing, this officer absolutely had probable cause to arrest Ms. Alpert for driving under the influence.
So I know the marijuana is a part and parcel. Was it actually tested?
I am not certain. It was, I will say,
leafy substance.
It was a green leafy substance that the officer testified to, and that to the extent that it may have been tested by the crime lab or that the Altoids tin was subjected to testing, those testing results were not admitted in the suppression hearing because they would not be part of the office. The ruling that the state is appealing here is really cabined to whether the officer had reasonable suspicion to shift from a traffic infraction investigation to a DUI investigation, and whether the officer had probable cause to arrest Ms. Alpert for the DUI. And so whatever lab results may have come.
Counsel, is this search in the car really just a red herring?
Or-
Let me just throw this out. She's being investigated for driving under the influence, correct?
Yes.
So they have the weaving lanes, they have her being talkative way too much. You heard a lot about her. You have the odor of marijuana. Even if you don't get into the car, doesn't the state have probable cause to arrest her for driving under the influence?
Oh, absolutely. Even short of the search of the vehicle, there's already probable cause to arrest her for the DUI. Absolutely.
So the court could have found search not appropriate, and the state could still have proceeded with prosecution.
Correct. If the only suppression was of the physical evidence recovered from the truck. But that's not the ruling that was made here. The suppression was concerning everything that flowed after the DUI investigation began, which was field sobriety results, the blood test results, any lab testing, and so on.
So the court, respectfully, ignored all those other factors that I discussed and only focused on whether there was probable cause to enter the car. In a sense.
It could appear that way, or that because the court had earlier found there was not PC that she possessed the marijuana, therefore there wasn't sufficient probable cause to arrest for DUI. But that ignores a whole wealth of additional evidence, being the odor, which indicates a time component, her talkativeness, the poor driving, the field sobriety testing results, her admission of smoking within hours of the stop, and so on.
And then the final blood test.
Correct.
Results.
Which neither side ever even got to, because the motion to suppress was hinging upon a moment in time that came before any of the lab testing. But yes, the suppression resulted in all of that being suppressed.
Even though they're two different tracks.
Correct. So to the extent that the preliminary hearing ruling impacted the trial court's suppression ruling, it appears, if anything, that it tainted it, or it infected it with a line of reasoning that, while it may have supported the conclusion that she did not knowingly possess marijuana in the truck, that conclusion shouldn't have diminished the trial court's recognition that the state absolutely had probable cause to search the truck and to arrest Ms. Alpert for driving under the influence.
You are up against your rebuttal time. If you want to waive any of that, you certainly can and continue, or you can proceed with the 5 minutes rebuttal.
I'd rather not waive it, so I'll have a seat. Thank you.
Thank you.
Please the court. I would note I was not on brief for this issue. I took over this case after Mr. Stolte took a position at the Wyandotte County DA's office. That would explain why it is quite a bit shorter than my typical submissions to this court. And while I'm still working on getting shorter, I'd like to use another acronym I try to use sometimes in my writing, is to just try to keep it simple on this case. The district court's ruling bears some examination on the suppression issue, in part because this is a state's appeal, and the state had the option to ask for additional findings of fact or conclusions of law. In fact, the court gave them an opportunity to request those additional findings, and they declined. So that triggers a presumption that we have to presume the district court made all the factual findings necessary to support its legal conclusion. The issue we have here is, I'm not contesting that if there's an odor of marijuana, the case law says that's probable cause. It's still illegal in this state, and until that changes, even I'm not brave enough to try to flip that precedent. But the issue we have is, I don't think the judge actually made a finding there was an odor of marijuana, because that is what makes sense in the context of the district court's ruling and the language it uses. It goes through, it talks about, it read the response, it talked about it not being the defendant's trunk. And on page 56 is where we talk about the smell of marijuana. The judge noted during hearing, the deputy testified the smell of marijuana was not coming from the person of my client. It was not coming from her breath, from her hair, from her clothes.
Even so, even let's say he doesn't address odor of marijuana. What about all the other things?
I think the issue we have is that the deputy testified that the findings in the truck were part of their probable cause to get to the field sobriety test. The deputy also confronted my client with what she found, saying, where's the rest of the marijuana? I think that we could go a couple different ways, but it feels like this taints the whole flow of things. And if the state wanted to challenge this ruling, then they needed a clear ruling for this court to analyze. Otherwise, we're back into the presumption, because I think the court can read this record, and the testimony is that the district court did not find substantial competent evidence to support the deputy's testimony that there was an odor of marijuana to trigger that search. For one, the court spends probably the biggest chunk of time in his ruling on the fact that there was so little marijuana, they had to hold a Ziploc baggie up to the light. And that was in a truck, which you can see from the video, which is included in the record. It's a landscaping truck. It's got leafy green debris all over it, but it's not marijuana. And there's no lab test admitted at the prior hearing. There was just a field test.
This seems to all be going very far afield from the DUI, and maybe we're just in separate lanes. But whether it was field tested, how much was in the baggie, and we're more concerned about how much is in her person and the way that the officer is observing her behavior. And this all started with the weaving lane. And then even if you don't have the odor of marijuana, you've got her talkative nature, her admission that she consumed marijuana. So I'm not, help me understand why you hinge so much on the odor piece.
Well, I think that the odor piece triggers the admission and triggers pulling her out of the car and triggers the rest of it. But the district court, the argument for the district court by the defense was this was a hunch, and they went and found evidence to support a DUI. And the district court's findings about the amount of marijuana, and in particular, the deputy also testified that she could not tell where or when the marijuana had been smoked. So we don't have a fresh odor. We don't have a significant amount that would produce a fresh unburned odor. And from there, the field sobriety test and the rest of the evidence the court considered, it referred to it as a very close case. And there's pluses and minuses on either side. And there's a video that the court was able to review. My client had a plate in her leg and had just had abdominal surgery, but the deputy didn't consider that when scoring the tests and sort of blew off the fact that your physical ability is.
Was he aware of that fact in the testing process?
She did not follow NHTSA protocol to ask it up front and was only aware of it after the field sobriety test. And I think it happened sometime after the one-legged stand was when they asked about that. But she testified she did not include that in her scoring of the test. My client passed the alphabet test, but overshot the number test. It's kind of a wash. The overly talkative, the court had the opportunity to observe the demeanor. I'm overly talkative. And while that may be an indication of impairment, it is not quite the same kind of slap bang, bloodshot eyes, odor of alcohol coming from you. And this was a marijuana DUI. So she doesn't smell like marijuana. She doesn't have bloodshot eyes. Her eyes aren't droopy. She's not slurring her speech. She just talks too much, as perceived by the deputy. On the other hand, we've got
those fact questions for a jury versus probable cause to proceed with the DUI investigation.
I think the judge weighed that as part of the totality of the circumstances and how he was going to weigh the evidence presented, which is his prerogative. He repeats that he's looking at the totality of the circumstances. And there's no indication he did not apply the correct legal standards. Of course, we'd have a lot more if we had a request for findings of fact and conclusions of law. So in the absence of him saying, I'm applying probable cause to, the wrong portion of this search or reasonable suspicion to the wrong portion of this search, we have to assume he got it right. And I think that was the core of his ruling, is that there's a little bit of this, a little bit of that. It could go either way, but that he did not find that it objectively amounted to more than a hunch. And that was his finding based on the facts. And there's substantial competent evidence to support that. We don't have really a specific challenge to a specific fact finding. And the court was able to view those, make his own determinations and weigh them how he chose to do so, including weighing the credibility of the deputy, which I think takes us back to that. This is kind of where it all started rolling downhill. Is I don't think the judge believed that there was an odor of marijuana, and therefore that triggered the rest of this, and it flowed into it. But again, I'm just guessing based on the record we have. There's nothing else. I'll leave the state's challenge to the Supreme Court tested precedent on the substantial impairment for another stage of briefing, hopefully, if we have to. But otherwise, I don't have anything else unless the court has other questions.
Ms. Sigma, I commend you for arguing somebody else's brief. It's a hard job to do.
Ms. Sigma notes that the district court did not explicitly find on the record that there was an odor of marijuana emanating from that trunk. The district court didn't need to do that. The state did not. She's correct when she states that the state did not request the district court to make specific findings of fact as to each event that occurred in this traffic stop. That's not required. That's not the standard. This is not a 1507 where the district court needs to provide written state findings of fact and conclusions of law such that appellate review has that record to build from. Rather, this court has both the transcript from the suppression hearing and the court's ultimate ruling. And to the extent that the defendant hinges her argument on the odor of marijuana piece, which this court had just asked about, it would appear that at least part of that is because the odor of marijuana piece, which was significant to the officer at the roadside there, is just about the only indicator of impairment made by the officer on that scene that day that is not independently and objectively verifiable by all of us watching the video. We can objectively, independently analyze the alphabet test, the counting test, the walk and turn, the one leg stand, the admission of use, the admission of smoking earlier that day, the search of the truck. We can observe all of that through high definition body cam. But what we cannot observe is the odor that the officer noted that day. And the officer's testimony of that was credible from the jump, not just because she later during a DUI investigation found marijuana in the truck, but because when she approached Miss Alpert, who was not argumentative with the officer or disrespectful, who was talkative and appeared distractible, but was not argumentative or rude to the officer. But when the officer approached that driver's side window that day, she noted and spoke of the odor of marijuana within the first minute of their interaction. And there's credibility, there's credence to that observation based upon the timing of her noting of that, because this isn't something that she developed later along the way. This isn't some officer who kept meandering through a traffic infraction investigation seeking to build probable cause of something else, who then later said, oh yes, by the way, while I was at the driver's side, I could smell marijuana. Rather, this officer noted it from the outset of the stop. And that was a credible assertion by the officer as seen in the body cam. And as she testified to, the district court never indicated that they did not find the officer's testimony credible. Rather, the district court said this appeared to be a close case. And it appears to me that the district court, the ultimate conclusion drawn by the district court was not as a result of a lack of credibility by the officer in the testimony, but rather the district court's mistaken belief that these facts and circumstances did not rise to probable cause. And the state's argument here is that at every step along the way, as reasonable suspicion was building to pursue the DUI investigation, probable cause was abundant, that DUI was underway, and that the arrest of Ms. Alpert was justified by all of those facts and circumstances.
How would you respond to Ms. Zygtema's assertion that, once the court throws out that odor of marijuana, we have nothing else other than essentially the impaired driving?
Impaired driving and the observations the officer made leading up to at least before the search of the truck. But this court should not discount the officer's testimony of the odor of marijuana. But I believe as though it's going to be tough to separate everything that flowed from that, because the odor of marijuana informed the officer's approach to the rest of the investigation, including the questions that the officer asked of Ms. Alpert and the search that was conducted of the truck and so on. Even during the field sobriety testing, the officer did not just utilize tools for recognition of alcohol impairment, but rather utilized tools examining drug impairment. The lack of convergence test was done with Ms. Alpert, and the lack of convergence test is not one that is used for alcohol impairment, but rather used for narcotics impairment, drug impairment. And the officer conducted that examination of Ms. Alpert on the roadside there, which also showed indications of impairment. That was yet another one of the bricks of the wall there, of the totality of the circumstances that led to this officer arresting Ms. Alpert on the roadside that day. The innocent explanations that Ms. Alpert offers for each of her failures on the field sobriety, that's not the proper lens through which this court should examine the conduct on the roadside that day. While there can be an innocent explanation or a lawful explanation for each of her failures, that's not the lens through which this court should examine whether or not that officer on the scene that day, under the totality of the circumstances, had probable cause to believe that this defendant was involved in criminal activity that day. There can be, we see this in every DUI investigation under the sun. There's an explanation for the failed walk and turn, of physical of surgery or a previous injury. The officer may not have asked if the person was proficient in the English language when they failed the ABC or counting test. And so we hear these innocent explanations all the time, but that's not the lens through which we should be considering whether or not that officer had objectively reasonable basis to arrest Ms. Alpert. If the court has any further questions, I'd welcome them, along with any questions about the substantial impairment piece. I don't believe as though that was briefed by Ms. Alpert, but I maintain that interestingly, under 22-3602 and 3603, those are the two statutes by which the state can seek an appeal of a district court's ruling, either suppression of evidence in an interlocutory appeal, that's one statute, or through the state can appeal the dismissal of a complaint under the other statute. Under that other statute about the dismissal of a complaint, there's a subsection within that statute which states that the procedures for that state's appeal shall be as set forth by Kansas Supreme Court rule. In the interlocutory appeals statute, there's no such subsection. And the Kansas Supreme Court created the impairment or the substantial impairment rule out of whole cloth. It finds no basis in the statute.
It's not an issue before us.
I briefed it. I raised that in my opening brief in this case.
Well, I understand that, but the defendant did not respond. Is that correct?
That's correct.
That's my recollection of reading the briefs. That's why I was asking.
I agree. I seek to preserve that issue with this court in the event that we find ourselves arguing this case another day as well. But
One of us is in strong agreement with you.
I have recognized as much, and so I hope that continues.
I just want to note that that case that is referred to are the same judges that sit on this panel.
It is.
It is.
It's the entire panel
The
that's
entire panel. So we're very much aware of the
Oh, now I
dissent
know what
and the
you're saying.
brilliantly written majority opinion by Judge Schroeder.
which I believe we may have argued in like the room next door or something last summer.
I have no idea where it was, but I would have told you it was here, but I don't know. I just remember the case.
It may have been, as do I. So
It was brilliant.
the dissent. Correct. I agree.
Terrible facts, but I agree with the answer.
I cannot push back on the fact piece, but thank you for your time.
Thank you.
Thank you.
Thank you.
Nice
Counsel.
job, counsel. Both of you.